Hello, you're on to Law Minstrel. I am Mwisi Mudukwe Nyim. So we are going to be doing something on evidence today, and it's no better place to start than the very beginning, which is an introduction to the law of evidence. We are beginning this journey into one of the most foundational subjects in legal practice, the law of evidence. No matter how strong your legal right may appear, it remains practically useless until it can be proven before a court of competent jurisdiction. So, any plea before a court without evidence advanced in favor thereof will fall because there would have been nothing to sustain it. Thus, in the case of Awojugbagbe Light Industries Limited versus Chinukwe, the court held that pleadings not giving support by way of evidence are deemed as having been abandoned. So you will see that evidence is the lifeblood of litigation. It determines what the court may hear, what it may rely on, and ultimately whether a party wins or a party loses altogether. In this lecture, I'll be going through what evidence means. We'll also take a look at what the law of evidence equally means. Then we'll look at the history of evidence in Nigeria, and finally we will examine why this subject is essential in legal adjudication. But before we delve into the core issues we are looking at today, I just want to take a breather and ask you to subscribe to our channel if you haven't done so by simply clicking on the subscribe button. Like our videos, share them, and interact with us by commenting in the comment section, please. Thank you very much. So what really is evidence? What's the definition of evidence, as well as what does the law of evidence entail? We begin by looking at what evidence means. Now, I always want to lay a background when I have to make a definition of any legal concept whatsoever. And I like to say that there is actually no definition that ends all definitions of evidence. So, in a very loose sense, evidence refers to any material whatsoever, whether it be oral, whether it be documentary, or whether it be real or physical, that is presented before a court in order to prove or disprove a fact in issue. So one good place to find definition of evidence should actually be in statute. Unfortunately, the Evidence Act does not define what statute is, what evidence is, but we refer to a sister jurisdiction among the Commonwealth, particularly the Indian Evidence Act of 1872, which defines evidence to include: one, all statements which the court permits or requires to be made before it by witnesses in relation to matters of fact under inquiry. Such statements are called oral evidence. Two, all documents, including electronic records, produced for the inspection of the court. Such documents are called documentary evidence. So you see this definition particularly under Section 3 of the Indian Evidence Act. But one key thing you also notice is that that act succeeds at simply defining what oral evidence and what documentary evidence entails. So it still leaves the crucial question of what evidence in general means. We will use the definition as the act gives it to guide us to give a definition that is a little bit more encompassing. And to this extent, I have tried to do that by couching evidence to mean all statements which the court permits or requires to be made before it by witnesses. All documents, including electronic records, produced for inspection of the court in relation to matters of fact under inquiry, and all other things that may be brought to court or the court may be moved to go and inspect in order to prove or disprove a fact in issue. So in this wise, you will now notice that evidence would include the testimony of witnesses, the statements or documents tendered in court, as well as real evidence such as objects produced for inspection. Thank you. So you have similar common word parallels, and to this extent, we'll be looking at the case of R versus Baskerville, and the citation is given on your screen. So, in which case, evidence was described broadly as any material that assists the court in discovering the truth. What therefore is the law of evidence? We have examined what evidence is. Now, what is the law of evidence? In a very loose sense, the law of evidence is the law of course that relates to evidence. It's the law that governs evidence. So, in other words, you be looking at the law of evidence as the rules and regulations of evidence that govern how evidence may be given and how evidence may be received or in admission or admitted, so to speak. So, and because we have rendered evidence to also include the rules that govern, we have rendered the law of evidence to also include the rules that govern evidence. You will now find that there is another way that law of evidence is called, and is sometimes referred to as the rules of evidence. To which method it covers the rules, the legal principles that govern the proof of facts in any legal proceeding. So it is these rules that determine what evidence may or may not be considered by court in reaching the judgment or decision that the court would reach. It is equally the purview of the law of evidence to set the quantum, that is to say, the amount, the quantity, and the type of proof needed to prevail in a given litigation. So these rules do not go across board. Instead, they vary depending on the subject matter of the litigation as well as the court of jurisdiction of the particular issue. In sum, the law of evidence is the body of rules that governs 1. What material the court may consider. It also governs how much material is to be presented before the court. It also governs the weight the court should attach to each of such materials, and finally the rights and the obligations of the parties when proving such facts. So, as Wigmore famously put it, the law of evidence is the system that determines admissibility, relevancy, and weight of proof. So, in sum, the law of evidence governs the issues of admissibility, it governs the issue of relevancy, and it also governs the issue of weight of proof. Thank you. We'll now look at the history of evidence in Nigeria. So in Nigeria, before the advent of colonialism, which saw the eventual reception of the English common law, the law of evidence was to be found in customs, and these customs were made up of the indigenous customs of the indigenous persons found within the country, as well as the Islamic customs that are governed by the Quran, as well as Islamic scholars. But with the incursion of colonialism and the eventual reception of the English common law by the establishment of British style or English style courts, the common law was received, and along with it the common law of evidence, and that's the that's the law that we have in Nigeria today. Basically, they received English common law on evidence, but it's said that the 19 and this journey began actually with the Ordinance Act, the Evidence Ordinance in 1943. But the act, as we are seeing it today, is said to have had its journey clearly marked by the 1979 Constitution, which now declared evidence to be a federal legislation, making evidence to become in the exclusive lists of legislation. So that's the journey of the Evidence Act that we have to this day, and of course it is intermittently being reviewed, as it were. So how important is evidence in litigation or in the legal process generally? The law of evidence serves several crucial functions in the administration of justice. One of it is that it ensures fairness in proceedings. Now, by that, only relevant and admissible as well as reliable material are presented before the court. This protects parties from surprises and prejudice as well as unreliable testimony. Another way that evidence helps is that it helps the court to arrive at the truth through rules on burden, standard of proof, admissibility, corroboration. The law filters facts to help the court make accurate findings and therefore make more accurate decisions. Now, evidence also protects individual rights. How does it do this? Rules such as exclusion of illegally obtained evidence and the right to silence protect constitutional liberty and order. Standardized rules enable lawyers to prepare cases with more certainty, facilitating structured litigation as well as reducing arbitrariness. The law of evidence also helps to balance efficiency with justice. By regulating what may be proved and how it may be proved, the law avoids unnecessary delays and prevents irrelevant material from overwhelming the courts. Now, by way of conclusion, as you can now appreciate, the law of evidence plays a central role in legal practice. It determines what, how, and who of proof. Understanding evidential rules is indispensable in litigation. You can't do without understanding the rules of evidence when it comes to litigation. So whether it is in civil matters, in criminal trials, in arbitration proceedings, or what have you, you cannot overemphasize the importance of the rules of evidence. So this introductory foundation will guide our subsequent discussions on the law of evidence generally. Such other issues as, say, burden of proof, admissibility, documentary evidence, digital evidence, expert testimony, and many more that we'll be looking at in subsequent episode. But before we leave, let me just do a few recommendations for your further reading. You can pick up an evidence act of your jurisdiction. You can look up Aguda on the law of evidence in Nigeria. You can check on Wadialo's modern Nigerian evidence. You can also read Phipson on evidence. You can read Cross and Tapper on evidence. And you can look up case law on evidence. It will also help you to understand the topic better. So, having come this far, how would you define the law of evidence in your own words, and why is the law of evidence, or why is evidence essential in adjudication to you? Let me hear your response in the comment section. Thank you very much. Till next time, I remain Wisi. Please don't leave without having some subscribe button and subscribe to the channel. Like our videos, share,